Do you have firearms in your possession?
Not currently in my possession. When the first protective order was issued, I do own two firearms, and I had my brother-in-law lock them up in his pole barn because I don't
Okay.
want to get rid of them. And
Welcome to the Harrison Brothers Showdown. John says Rodney violated a protective order and wants a clear buffer zone around the Kent City property. Rodney's on the phone, facing possible jail and fines. This is family, probate, and PPO drama. Colliding, so buckle up right now, today, and subscribe, like, share.
Two matters come before the court today. First is Mr. John Harrison's request for an order to show cause why Rodney Harrison shouldn't be held in contempt of court for alleged violations of the personal protective order. And then the second is a request by John Harrison for modification of the personal protective order to state a specific distance or perimeter that Rodney Harrison would not be allowed in to prevent him from observing and certain work that's going on at 4297 Lutheran Church Road in Kent City, Michigan. So, as an initial matter, Rodney Harrison, you are here by telephone only. I'm going to swear you in, advise you of your rights on the order to show cause, and then I'll take your plea of guilty or not guilty. So would you please raise your right hand?
Yep, I'm sure we got a camera here in the hallway outside your courtroom.
Indeed, I do, and I also trust that you have it raised. Rodney Harrison, do you swear that your testimony today will be the truth and nothing but the truth, so help you God?
Absolutely, sir.
Very good, thank you. And Mr. Rodney Harrison, you understand if I find you guilty of violating the personal protective order, I could find you in contempt of court, and thereby I could put you in the Kent County Jail for up to 93 days and or impose a fine of up to $400. You understand the potential penalty?
93 days and how much money?
$400.
400? Okay.
Yes, and you also understand that if you dispute the personal protective order, that is, you don't think you violated it, you're entitled to an evidentiary hearing on that issue. I'd conduct that in my courtroom. Sometimes I conduct them by Zoom, but since you showed up at the courtroom today, I guess my inclination would probably be to do the hearing in person in the courtroom. During that hearing, I would appoint an attorney to represent you. If you'd like to be represented by an attorney, but you don't have the funds to hire your own attorney, I'd give you a court-appointed attorney because that jail time is at issue. And that attorney could cross-examine petitioner, Mr. John Harrison, as well as use the subpoena power to bring in any witnesses that you thought were necessary to tell your side of the story at the hearing. So you understand your right to a hearing.
Yes, I do, sir, but I do also understand when I've been in front of you last several times with Stephen Hecknell and Patricia Epler, they did nothing.
Yes, no, sometimes, well, the right, bear in mind, is to an attorney, not to the unfortunately best attorney or to an attorney who's going to argue exactly like you want to. It's just to assure representation in every case where there's potential jail time exposed. And I do not know which attorney, of course, you're going to get, but I do know that, when you're getting a court-appointed attorney, it is a situation of you kind of take who you're assigned rather than getting any choice in the matter, like a person who hires their attorney. So that is
Go ahead, sir.
How it works. So anyway, so at this time, do you wish to enter a plea of guilty or not guilty to the violation, Rodney Harrison?
Not guilty.
Very well. I'll enter a not guilty plea, and I will set a hearing date and time. Lisa, do we have that now, or are we going to have to send it by mail?
No, I have it. I have January 29 at 1:30 in person.
Okay, that'll be January 29th, 1:30 p.m. in person on the 8th floor of the Kent County Courthouse in my courtroom.
hold on, January 29th to 26th at what time, sir?
1:30 p.m.
1:30? Okay, I am also working with a possible attorney to help me on this, but he advised me to take the court-appointed attorney, and he said if I'm not happy with him, I can probably retain him. I want that on the record today too, and that gentleman is Bernard Schaefer.
All right. I'm very familiar with Mr. Schaefer. He does a fine job. So I will note that if you do want to retain Mr. Schaefer, you should get him on the books and retained. I will, if you'd like to try a court-appointed attorney first, I'll send you the paperwork when we send the notice of that hearing, and you can submit that. We'll get an attorney appointed. You can speak with that person and determine then which way you want to go. The one thing I'd caution you against is don't wait until January 28th to make that decision, because then it's going to be too late. We'll have to conduct a hearing on the 29th with whoever.
Well, I guess that all depends how fast I get to talk to this attorney you're appointing to me and see how good he is, because we know Bernard Schaefer will play cleanup, because he's done that in Murkowski's courtroom in a matter of probably 15 minutes of another court order where John tried to sell my house without.
All right. Well, I do know Mr. Schaefer, and I know he does a fine job. So I'll just, leave it to you. I also know, of course, he is a private lawyer, so he is going to require a retainer and all that good stuff. So you'll have to come to your separate arrangement with Mr. Schaefer. All right. Let's move on to the modification of the protective order to clarify the distance here. The order itself, of course, says that Mr. Rodney Harrison is not to be within sight of John Harrison. Mr. Harrison reiterates John Harrison reiterates the claim that Mr. Rodney Harrison is parking his truck or driving by in his truck, that location, 4297 Lutheran Church Road in Kent City, thereby, appearing within sight and violating the order, and requests an extension of the distance or clarification, I guess, of the distance out to 1,000 yards. Is that accurate, Mr. John Harrison? I can't hear you, Mr. Harrison. I could before. I can hear a little bit of what you're saying.
Okay.
There we go. That's better.
Is that better? Okay. I'm a little closer to my computer. The issue that I'm running into, Your Honor, is Rodney is driving by that address that I mentioned. He's also parking off the edge of the property within, or I would say just over 200 yards each direction, watching me and surveilling what I'm doing on that property. I am a court-appointed conservator for my mother and have exclusive rights, as stated here, the authority with respect to all assets of the estate. And the work that I'm doing on that property is moving equipment around to get them out of buildings that are falling down. And Rodney is continuing to surveil me. He's called the police on me twice for suspicious behavior, for attempting to stealing property that doesn't belong to me. He's called Adult Protection Services in regards to activity, saying that I'm misusing my mother's financial assets. And he's also called the Kent County Sheriff when I was trying to get that property to perk, and turned me in for that property not having an appropriate septic, which ironically was a septic that Rodney put in for his mother when he was her caretaker without a permit and plumbed it into the ditch. So what I'm trying to avoid, Your Honor, is him continually, basically surveilling, stalking me, and impeding my ability to basically take care of my mother's estate. That property is for sale. We've accepted an offer, and as we move forward with a closing, I can only expect that his surveilling and driving by that residence is going to continue or get worse.
Question, in your estimation, if he's approaching that area, how far can he tell if you're present or not present there? Could he tell that before he hit 1,000 yards, or is he going to have to come within 1,000 yards to determine whether or not you're on the
Well,
property?
he basically would, I would have to be in the driveway of the vehicle, but he knows when I'm there, but then he still continues to drive by again or turn around or park up on a neighbor's property watching me.
Got it. And you
Uh,
don't really care if he's within the distance, I mean, of that property when you're not there. It's when you're there working on the property or taking care of something that you don't want to be surveilled or watch over.
Well, that's basically it. But as we move forward on that property and there are more people there in regards to if we have a sale or people are picking up items from the estate, he has impeded people's ability to see the property. He's made realtors a
Objection
bit
to,
uncomfortable
you
in
know, we-
regards to seeing the
I'll give you a
property.
chance, Ronnie.
And
Yep, thank you,
and
sir.
I've also heard from a potential viewer that they're kind of losing interest and don't want their family members there because of Rodney. So, he's parked across from the property, not just when I'm there, but when other people are actively there showing the home or viewing the property for purchase. So to me, the best effort may be to just not allow him to even be on that road until maybe April of next year when we finally close and button up this property. That road is not a active road that prevents Rodney from doing commerce or traveling from one location to the other. He can go 15 mile, he can go around to 14 mile, but his ability to utilize that road does nothing but affect and harass me regularly when I am there on that property doing work.
And Mr. John Harrison, is the road you're referring to Lutheran Church Drive?
Yes, it
The
is,
road.
sir,
Okay.
Your Honor.
Yep. Okay. All right. Thank you. All right, John Harrison, what's your response? Or I'm sorry, Rodney Harrison.
Okay, sir. We need to put John under oath because I just witnessed numerous lies for perjury.
All right. Well, I guess I swore you in. I will swear him in as well. Mr. John Harrison, if you would raise your right hand, you solemnly
Yes, Your
swear
Honor.
or affirm that your testimony today will be the truth and nothing but the truth, so help you God.
I do.
And were the last statements you just made to me true to the best of your knowledge and belief?
They are all true, Your Honor.
Okay, very good. All right, Rodney, why don't you tell me your side of the story? You do remain under oath as well, of course.
Beautiful. I'm just writing some stuff down. I have numerous friends on that road that I share vegetables from my garden, which, is over with now. But
This is Lutheran Church Road?
Correct, 4297 Lutheran Church Road.
Okay.
I have neighbors. They are my neighbors, since, I've stayed with my mom when she had back surgery, had cancer surgery. Nobody wants to mention that. John said that I put in the drain field for my mother. I did not
I
put my
can't hear
drain.
Rodney when he speaks, Your Honor.
You can't, I can hear Rodney just fine. I'm not, can you turn up your speaker or your volume on your side, John?
Well, it's what it's doing is it sounds like it's breaking up, Your Honor.
Oh, I'm getting him loud and clear. I don't know
Yeah.
why that is. So, well, I'll try to convey what he's saying as
All
best
right.
I can since you seem to be able to hear me okay. You can
Yep.
continue, Rodney. Yeah, I
Yes,
get it. You dispute the drain field, but that's not really the issue here. The issue primarily is, um, you know, what business, you mentioned the fruit and vegetables that you share with your former neighbors along there. What other business do you have being within 1,000 feet of that piece of property?
the neighbor directly west of Mother is Jim Rohde. He's a very close Christian friend of mine. We do a lot of praying together. I stop by his house and pray with
How
him.
far
He
would you
prays
say
with
his house is from your mom's house?
probably maybe under 250 yards.
Okay. And
I would
that's
check that distance, Your Honor.
that's that is the distance you think, Mr. John Harrison?
No, it's not. As I stated earlier, the edge of the property line from where the residence sits to the edge of the property line to her west. That is 200 yards exactly to the property line. Jeff Rohde's home is probably 275 yards, maybe 300 yards from my mother's residence to the west. I don't have any
No, it
issue with
isn't.
Rodney going to that property, but he can access it from Kenowa and not have to drive by the property. And from Jeff Rohde's, he cannot see the activity going on at 4297 Lutheran Church Road.
Okay, all right. No,
The name is Jim Rohde, and it's
All
not
right. Jim Rohde.
okay. And Chris and Mary Hamill live probably maybe 300 yards away on the opposite side of the road, farther west of Jim Rohde, that are very close friends of mine that I help Chris, who's handicapped now, do things around his home that he cannot do by himself, and his wife is not able to help him with.
okay. But
And
if
I
he's
also-
further west, then you're not going to be able to necessarily see what's going on at the farm, even if you are allowed to be on that property. Is that accurate?
I probably couldn't see from Chris and Mary Hamill's home, no. But
Okay.
I also deal with the Mamerland Lutheran Church, a good friend of mine up there that's a janitor, and a couple other gentlemen that I stop and talk to, and also share vegetables with at the church.
And that's on Lutheran Church Road?
That is correct.
And how far is that from your mom's residence?
Probably 200 yards roughly in the other direction to the east.
Okay.
Could you repeat that, Your Honor, just so I can be in the loop?
Yeah, he's also saying that he sometimes stops to speak with or share vegetables with a couple of maintenance people at the actual Lutheran church, which is 200 yards east of your mom's house
All right.
there.
Okay. Can I offer a clarification,
Yeah,
Your Honor?
I'll give you a chance afterwards. Let me
Okay.
hear Rodney out first, and then
All right.
I'll hear your side. Go
Okay.
ahead, Rodney. You can continue.
I think this is absolutely ridiculous. You know, all of this conservatorship that John got from Murkowski, he is hiding behind with the PPO that you said that you gave him. And all of this is a tool to keep me from, telling the truth to everybody how all this is going down. Under MCL 725.423 subsection 3, per John's letter of conservatorship, he could not tear down the barns. He could not arson the barns, which is
I'm
why
not
I
going to
called the sheriff.
interfere with Judge Murkowski's letters of conservatorship or any change. If there's anything to be changed there, it does need to be in the probate court in front of Judge Murkowski.
I'm not asking you to change it. I'm telling you, John's letter of conservator does not allow him to tear down the dairy barn, the hog barn, the lean-to, and the corn crib, and throw a match at it 2 separate times, which is arson without the authority of Judge Murkowski.
Right.
That's
Well,
the
again, you're
problem.
going to have to take it up right with the probate court I'm not going to, as I think this through, John, I'm not going to put in an order that prohibits you from calling, law enforcement. Although, I am as concerned as the two of you are that we not rename the North Substation of the Kent County Sheriff's Department the Harrison Substation because they're getting so many calls about this matter. But nonetheless, my view's always been when people are calling law enforcement, that's an appropriate route. It's not direct contact with the other person. And then law enforcement makes a report and sorts it out per their law enforcement training and, ability to deal with a call. So I'm not going to limit those things. You're able to make, of course, reports then to the sheriff's department or the, whoever the health department on the perk thing, those things are just, they're government reports that get made in the ordinary course of business, and the government office is in a position to be able to sort them. My main concern, John, is this presence within, and concern about you sort of parking and overwatching the property all the time. I can see where it would make your brother nervous on the property, given the water under the bridge, and also it would make any prospective buyers or people out there looking at the property nervous too if they think, well, I'm going to get the property, but I'm going to get this guy in his pickup truck watching me 24/7, I might be hesitant to buy a piece of property under those conditions as well. What are your thoughts? That'll go to you first, Rodney Harrison.
Okay, sir, you mentioned John when you were talking about me, is what
I'm
I
sorry
believe.
if I crossed you up. It's late in the day is my only excuse.
Yep, I just want to verify that you mentioned me as John. I'm assuming that's who you were talking about when you were talking
No,
about
no,
me.
the question was directed to you, and that, I understand John has this concern that you're parking, close to the property, whether it be for some other purpose or not, and kind of watching or surveilling the property when he's there. Um, what's this, he's offered up the solution. Well, Judge, let's put 1,000-yard perimeter around the property, or at least where he is on the property, and include Lutheran Church Road as a no-go zone in there. I can modify the order to do that. That seems like it would be the solution. However, I want to do it in a way that's least restrictive, to you doing your day-to-day activities as well. So I've offered you an opportunity here to tell me what's another plan I could come up with to achieve, what both of you are seeking here.
Okay.
Here comes the plot twist. Rodney calls the photo exhibits photoshopped, claims the barnwood pile was actually on fire, and says he called police for arsonaut surveillance. He even points to DocuSign-style markings like it's a conspiracy label. If these images crumble, John's whole contempt claim wobbles badly.
Or
Okay.
not what both of you are seeking. This is just what your brother is seeking. I know you would rather have no restrictions and be able to be at the property, but I've already knocked that out.
Well, that violates my constitutional rights of doing what I want to do freely. But
well, there's no such right, Rodney, that you can do what you want to do freely. There are enumerated rights in there, but us courts limit those all the time in one way or another. So, and if you think I am violating fundamental rights, of course, you should appeal it to the Michigan Court of Appeals. But I'm talking about a practical, on the ground solution here that might work.
Okay, my practical solution to this is, John has numerous flying monkeys, which is my sister-in-laws and siblings. John can call one of them siblings and call me and say, John's going to be at the farm at this date and time, through this date and time, and Rodney, you shouldn't be by the farm. That is the easiest and most effective way to not violate my constitutional rights or hamstring me for what's going on with my neighbors and my mother's estate. I would think that would be the best option you have, sir.
Kind of, you would ask that John notifies you, and he's going to be on the property, and you're not. What about this scenario where other people, maybe a real estate agent or someone else is out looking to buy it, and John's saying, well, if Rodney's sitting there on his truck looking at that all the time, that might lower the sales price. It seems like it's probably in everyone's interest to get the best price out of this thing, right?
Absolutely not, sir, because it is in my mother's will where I can buy the farm for $80,000 once my mother's passes. My mother was in an accident with my brother John, or conservator John, I don't even want to mention brother, on October 5th of 2024. My mother broke 8 ribs, her sternum, a collarbone, and both of her thumbs. And since then, she went from there to, that was in St. Mary's where she went. Then she went to a rehabilitation center, and then she went from there to a nursing home and set it back onto the farm where 6 siblings and sister-in-laws could have taken care of her. That was not in John's best interest because he wants to sell the farm because he knows I can buy it for $80,000, and he's had it listed for $685,000 to start with. Now he has 2 offers for $600,000 that we are going to be in front of Murkowski on December 1st for him to authorize this sale possibly, but with what I have to offer under that MCL 700-5423 subsection 3 is going to put a huge wrench in John's system and your system for what's going on today, because John cannot demolish, mortgage, sell anything, and he's done destruction of private property, which is 4 outbuildings of my mother's, a dairy barn, a hog barn, a lean-to, and a corn crib, and he lit a match to that on October 26th, which is in his complaint today, that I'm watching him, and he said, I took these pictures at this date and time. Well, the pictures that I took on that date and time, the barn was on fire with numerous siblings and sister-in-laws
Oh,
in
you
the
were
area.
speaking. I couldn't hear Rodney.
Yep. No, well, Rodney's saying, that now, Rodney, just to clarify, the pictures that I have from your brother appear to be pictures that he took. I don't see any that are purporting to come from you. And I also, I'm not sure that I have oh no, some of them have some, well, I'm trying to find a date here so I can, oh yeah, there we go. One of them's 10/4/2025, that the house was being shown, or it looks like a showing of the house. Of course, I don't know what's going on out there. And the others, I assume, are right around the same date and time. Oh, and I guess you're talking about October 2025 as well. So, okay, all right. And John, Rodney's saying that he's going to contest, the sale of the place in the probate court. Thus, maybe he doesn't have the interest in, getting the best price out of it as you and the conservator's shoes would. And of course, that's the extent of my knowledge of probate law. I leave it to Murkowski and Chief Judge Rose. Beyond that, I do know that, if you're in the financial thing, usually the goal, just like a bankruptcy trustee, is to recover as much money from assets as you can. But obviously, in probate, there are different interests that impact that. But that's why it's in the probate court, is because that's probate's bread and butter, is deciding such things. John, anything else? I'm going to go back to Mr. John Harrison now. Anything else to say before I make my decision on the?
I would like to continue, sir, if you would let me.
Okay, go ahead. I thought you were finished, Rodney.
Oh, you got to be kidding me. I got so much information.
I hear you. I just want to keep it focused on this matter, though. Let's keep it tight to what's going on here, this 1,000-meter perimeter.
On John's order of show cause hearing that I believe that you said you were looking at pictures of.
Yep.
Okay, go to the second to the last page, Exhibit 4, 2 of 2.
Isn't he talking through this handset, or has he got a speaker on to talk? That might be part of the problem I'm having.
Yeah, I'm not sure. I can hear Rodney Harrison just fine. John's having some trouble hearing you. I don't know. Is there any way you can make the volume louder from your end, Mr. Rodney Harrison?
I got it on loud as far as I can hear it.
Is he talking through a speaker or through the handset, Your Honor?
I don't have the answer to that because I don't have video.
I have everybody on.
There you go.
Everybody on speaker.
Got everyone on speaker.
I have everyone on speaker because my phone is so old, when I take people off a speaker, I can't even take a phone call and hear them.
All right. Well, I don't want to have you change things around so you can't hear. So just keep it as close to you as you can. Speak as loud as you can. I'll try to translate. Which picture are you directing me to, Rodney?
Okay, second to the last page. Okay. Exhibit 4, 1 of 2. Correct? Are you there?
No. Second to last page of pictures. Yep.
Yep. Top left. Exhibit 4, 1 of 2.
Is that the one that's got the line on it that says 200.9 yards?
No, it says on Sunday, October 26th, Rodney drives by 11:45 to 11:15 estimated.
Oh yeah, okay. I'm with you. It's my third to last page, but that's okay. I got it.
Okay. Well, it's my second to last, but anyway, those pictures are all photoshopped. We have 1, 2, 3, 4, 5 photos that are photoshopped. And John's, I'm assuming it's the topper of John's truck, the topper door that overlaps pictures 3, 2, and 3. So now we're looking at an exhibit that we're talking about today, since John's under oath and he said under the penalty of perjury, all this is true. These are not true pictures. That pile of barnwood that you can see in the pictures was on fire at that time, and that's when I called the sheriff's department for arson.
All right. Well, I guess, yeah, I got it. And the number one thing is that your truck I'm seeing there in those photos?
I could assume so, yes.
Okay. But it looks like the same truck. I mean, I'm not a truck ID expert either, but it looks like a white pickup truck with a double
right. They are not. These are not on that day and time of when I drove by that day.
Got it.
I can guarantee you that.
Okay. All right. No, I understand.
And then if we look in the top left corner, it says in the very top in fine print, you might be able to unstaple what you're looking at. It says docu envelope ID 7C180-138-DEE 0-493C-B791-17BC 62207B0. That is a file that John set up where he photo enhanced these pictures to get you to sign this order for show cause.
Well,
and that is
let me just pause you, Rodney.
evidence.
I don't have any of those markings on the top of any of my photos. I'm going to venture a guess that the set you have has DocuSign markings that we use in Turbo Court when I sign those things electronically. They get sent to me, and I sign them at times electronically. Although this one, let me see. This one I didn't have to sign, so I don't know. Those could be court filing marks too, Rodney. I'm not sure, but I don't have them on the original that I have here at the that's in my file, which is the original court files in front of me. So those aren't on there, so I don't think those are an issue.
Well, I believe they are an issue because I've Googled with the Michigan Supreme Court that they do not use DocuSign. So I don't know, and I'm not telling you. I'm not saying that
no, we're not the Supreme Court though. We're the circuit court, and we use it, and so it is it is part of our document flow here. So, all right, anything else, Mr. Rodney Harrison?
So you're telling me this could be your document of your file?
Yeah, the markings on top could come from the court. Yes. Okay,
what I'm telling you, those pictures are not of that morning of Sunday, October 26th at 10:45 to 11:15 estimated. And I can prove that.
Why does that make a difference though? I mean, as long as you were there surveilling the property at some point when your brother John was there, why should that make a difference?
I did not know my brother John was there. I saw the smoke, that's why I called the sheriff. And that's how all this, transpired. And then John turned it with all the pictures that are taken from my sister-in-law, Sue Harrison, who is his number one spy, flying monkey, with my brother Ken, who is married to Susan, and numerous other siblings. I can prove these pictures were not taken by John at this date and time, is what I'm telling you. And he said these are true to the best of my knowledge in the affidavit that he signed for this, to get you to sign this show cause hearing, and I just brought it to your attention again. These are not accurate.
What I'm hearing here is that regarding this, it's and the request for the 1,000-yard extension, the extension of it seems to me to be quite tied up in the same facts that I'm going to be exploring at the show cause hearing. So what I am going to do is I am going to hold off on this until we're all in court, since you're challenging the validity of the photographs.
Yep,
the photographs
absolutely.
Are essentially the evidence that he's going to use to support his request, both for the show cause, the violation, in your case, Mr. Rodney Harrison, and then secondly, his request to modify the order to go out to 1,000 yards, from the property, as opposed to, and I mean, bear in mind, right now the order does say within sight, and that means I interpret within sight to be within eyesight, telephoto lens sight, binocular sight. If he can see you, you should assume that, or you can see him, you should assume that he can see you. And if you're seeing him through binoculars or whatever, well, that's not gonna, I don't entertain at my hearings that this is kind of a spy versus spy thing where we try to out-tech each other with super, lenses and things like that. I view it a very straightforward that line of sight means line of sight. If one person can see the other or take a picture of the other, that means they could be seen from that situation. So I'm going to reiterate that that's what that means here and for that situation. I want to turn back to John Harrison. John, Rodney suggested the solution here of you contacting him via one of your siblings who might, not have a protective order with him, and notifying him that way of when you're going to be on the property. Is that manageable from your perspective? I can't hear you, Mr. John Harrison. You have to come a little closer.
All right.
There we
I'm
go.
saying no, it's not, because I'm the one with the PPO order and I shouldn't have to go and make extra work of it. My feeling,
jumping through a bunch of hoops to right whenever you need to go out
Yeah.
there and take care of business. No,
Well,
I get that, and that would create a
right.
lot of delays for
So-
anyone.
So here's my proposed solution. Rodney had mentioned that the distance from Jim Rohde's house to my mother's home was a couple hundred yards. From my mother's home to Jim Rohde's house, and I'm using an Onyx software package that I use for hunting and fishing, where I can place a point on her residence and then at Jim Rohde's residence.
Okay.
And give or take
Yeah.
5 or 10 yards. It's 370 yards, Your Honor.
Okay.
So,
I
and
don't
then
believe that.
from my mother's home to the church on the other side of the road is 442 yards from the home. So instead of me having to continually call and let them know I'm going to be out there, because sometimes it's very spontaneous. And I just
Understood.
need
And
to
there could be
drive
an
up there.
emergency or something, right?
Sure. So would you entertain that the 2 points that he cannot go past is Jeff Rohde's home to the west and the church parking lot or the parsonage where he delivers fruit to those individuals, and he can't be on the road in between that until we meet in court to have you hear both sides of the story and resolve this.
All right.
Judge isn't buying spy versus spy. He treats within sight as plain line of sight heaven, binoculars, and pauses the 1,000-yard request until the January 29th hearing. But he still tightens the leash, a temporary 350-yard boundary around 4,297 Lutheran Church Road. That means no casual drive-bys, period.
All right. That does sound reasonable to me. If we set those two parameters, that's going to be a little hard for me to put down in verbiage in the order. What I'm going to do is I'm going to say it's going to be 350 yards until the date of the hearing, because it already says within sight. And
Okay.
in my view, most people have a line of sight, that goes out at
Yes.
least 350 yards in the country like this. Let's set it 350 yards. That'll effectively set those two posts on either side of that location, and that is within 350 yards of 4297 Lutheran Church Road, Kent City, Michigan, until the date of the hearing on January 29th. At that point, I'll determine whether or not it needs to be extended, or if something has changed, it needs to be shortened, or we need to make more changes at the time of the hearing. But I think we'll just set that for the purposes of today, because I also have to decide, of course, the alleged violation at the time of the hearing. So I will send in an amended order that defines that at 350 yards. It sounds like the sheriff has been somewhat frustrated by the lack of clarity in the order, but that'll give them a number to work with.
Hold on. What report are you referencing that I know nothing about? Because the body cam footage of all these deputies that have showed up, I have done everything of what they've said.
No, right, and I'm referring, actually, I think John wrote it in here, in that when he calls the deputies and said, hey, this truck's kind of overwatching the property or whatever, when I'm out there, they say, well, the order itself is ambiguous as to the distance. Well, my view is it shouldn't be that ambiguous. It says line of sight. Sight means sight. But if the sheriffs need something more clear, I'm willing to go with 350 yards. It's a short enough distance for the time being.
Okay, so how do I know when John Harrison's there? That's still a
you're
problem
just
where
going to
he
have
can-
to use your own gifts of sight and intuition as to when that's occurring. And if he's there, you shouldn't be within 350 yards. And that's all there is to it. And you can't say, well, I got to drive by and get within 50 yards to see if he's within 350 yards. Same thing for you. You can see him from a distance away that he's there. That means you just turn around and leave. I don't sense that's going to be a problem. It's the standing, at different points and watching.
That is exactly what the sheriff's department told me. One deputy, Tucker, told me the exact same thing. If you see that he's there, back up. And prior to that, a deputy Parson told me, I don't care if you drive by 100 mile an hour or 1 mile an hour, do not get out of your vehicle. All of this is going to be in police reports and body cams for when you give me this
Yeah, I would caution
That's
you
it.
not, just don't drive by the exact address on Lutheran Church Road. That's going to certainly be within sight. And if you don't know he's there, you could violate the order, because you wouldn't figure it out until too late. So given the amount of, like I say, tension that's going on there, my advice
Well,
would
there's some
be
huge.
until you're positive he's not there, don't drive by on Lutheran Church Road.
So I can go to Jim Rody's house to the west.
You can
And
go to
pray with
Jim
him.
Rody's house to the west, and you can go to the church to the east, but no closer.
Understood.
Drive
This is gonna
past
be-
the property.
Right, and not drive past the property. That
So
right
he's
when
got it. He's got to see Mr. Rody by going Kenawa to Mr. Rody's home.
correct.
Just a point of clarification.
That would be my expectation.
Obviously, you can see that John Harrison got his butt hurt there a little bit because you can hear the cracking in his voice.
Well,
You know, this is gonna
I
be-
don't assess such things during these hearings. I just try to come up with, practical solutions that people can understand. I'm the trial court. The Court of Appeals does all that fancy stuff. So, all right, gents.
One question, Your Honor.
Yeah, go ahead, Mr. John Harrison.
You had mentioned that Rodney could bring witnesses to represent his side of the story. Is that also applicable for me, that people that have been working there who've witnessed him seeing and parking and surveilling can also be present to testify?
Absolutely, that would support your case.
All right, thank you.
All
do I
right,
need to make-
gentlemen, I greatly appreciate the both of you taking the time and dealing with the technology to be here for the hearing this afternoon. I often say it is more contentious when both parties show up for a hearing, but it also represents to me, then that means this is a case where the two parties are committed to following the rule of law and doing the right thing. And I think the both of you are. I understand you're in very much disagreement about some very important things here, but the whole process of the court here is we try to sort that out with words and orders and civilly like that, rather than resorting to self-help and kind of vigilante justice. And I greatly appreciate the two of you not going there. I can tell the both of you are committed to doing the right thing. I look forward to seeing the both of you in January. I wish both of you a safe and blessed holiday season until then. Thank you.
Thank you, Your Honor.
Thank you. God bless you, sir.
Thank you.
Are you there yet, buddy?
The matter of Julie DeYoung versus Karen Prisby.
And this matter comes before the court at this time on the respondent, Ms. Prisby's request to terminate the PPO granted in favor of petitioner Ms. DeYoung. Both parties are here, and I'm going to start out. I guess I'll swear in Ms. Prisby and have you clarify a little bit about what you said in your motion. I'll get a response from Ms. DeYoung, and then I can make a ruling on whether or not this protective order needs to stay in place. So, Ms. Prisby, would you please raise your right hand? Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
I do.
Very good. And Ms. Prisby, would you state and spell your full name for the record, please?
Karen Prisby, KarenPry.
I did PRYSBY?
SBY.
Thank you. Okay. And Ms. Prisby, you say on here you would like it terminated because it's not needed, that you acknowledge past issues. The two of you are sisters. Your older sister stays with your mother. And one question I had is one statement you made in here, a question about, you said, well, you're not able to see your mother unless arrangements are made to ensure that your sister's not there. And then you acknowledge again the two domestic violence situations that occurred in the past. And then I believe at the end here you say, well, Judge, we don't need this because my intention is to avoid petitioner, and I'll make arrangements to see my mother when the petitioner's not at my mother's residence. So, I mean, it sort of sounds like even if I lifted the protective order, you're still going to be doing stuff as if the protective order's in place.
Yes, that's correct. My goal is to avoid the petitioner or avoid my sister as much as possible. I'll continue to still make arrangements to prevent seeing her while I'm there, but it just makes it me to
Yeah,
drop
well, I
by.
mean, it sort of evens the playing field, if you will. I mean, right now, because she's the protected person, the onus is on you to make sure that there isn't that conflict. If you go there, although, I do note that I reviewed the underlying protective order that's in place here, and because of the way that this is Mr. Young made application, what it states here is that you are prohibited from assaulting, attacking, beating, molesting, or wounding your sister, that you are not allowed to threaten or to kill or physically injure your sister. You're not allowed to interfere with your sister at in place of employment or education, and you're not allowed to purchase or possess a firearm. However, it is not one that prohibits you, at least at this time, from being at the same location your sister is or within sight of your sister. That just was not included, that I recall, in the protective order, and it doesn't look like it's been amended to include any of those provisions. So I guess my view is the protective order as it exists right now, doesn't prohibit you from going over there if you were to, cross paths, say you're driving in and she's driving out or something of that nature. You're not going to be in danger of violating it. Just prohibits any contact or any threats between the two of you. And also, it does prohibit you from possessing a firearm. I noted one of the things your sister said in her request for an extension is she's afraid of you and that you have access to firearms. Do you have firearms in your possession?
Not currently in my possession. When the first protective order was issued, I do own two firearms, and I had my brother-in-law lock them up in his pole barn because I don't
Okay.
want to get rid of them.
Switching cases, the sister's PO stays put. Karen wants it terminated and flexibility to hunt or target shoot, but Julie says the death threat was real and recent. The judge agrees. No relaxing firearms rules, no new purchases, and the order remains until November 9th, 2026. Peaceful compliance is the benchmark.
And the hard part is too, is I actually do like to deer hunt, and so I'm unable to deer hunt with a firearm based on that also.
I see. Okay. So the firearm provision there eliminated you from hunting because you can't possess a firearm. Okay, well, and it's possible too that I can adjust this to allow you to hunt, but not otherwise, possess a firearm, for any other reason. So I have done that in the past. So, okay, anything to add, Ms. Prisby?
Well, I do actually like to go out and target shoot at local gun ranges, so under the current order, I'm unallowed to do that. I'm allowed to do that.
Yeah, well, we could include, and I'm certainly going to ask Mr. Young about what she would like here going forward, but it's possible to modify these to allow activities like that as long as they're not perceived as any way threatening. So, all right. Well, anything, let me swear in Mr. Young and ask where she stands. Mr. Young, if you'd raise your right hand, do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes, I do.
Very good. Mr. Young, I take it you would like the order to remain in place, and you've requested that I extend it, and I have granted that, and I've extended it, I think I want to say until 2026. Is that right?
That is correct. Yes.
Okay, and still you'd like to have it in place?
Absolutely. Yes.
Okay, and what's your position on modifying it to allow, it would say something along the lines of under their purchasing or possessing a firearm with the exception of possessing a firearm while hunting deer during deer season, and also, in the course of doing target practice at a certain range for that purpose. It would limit her use of the firearms, or her possession of the firearms is really the number one thing. and especially now within the day of high risk protection orders or extreme risk protection orders, the idea is that you don't have access to that firearm 24/7. You have it for defined purposes. How would you feel about that, Ms. Young?
Your Honor, I'm very uncomfortable with that.
Okay.
She lives with my sister and brother-in-law, apparently the guns are at that
Yeah,
house.
so they're at the place. They're just
Yes.
locked up out of her
That's what she's
area
saying.
of control.
That's
Yeah,
what
I
she's
see.
saying, yes. And with the fact that she told me she was going to kill me 2 inches from my face, I'm just not comfortable with that.
Yeah, I get it. You're still afraid of that occurring. So,
Absolutely.
all right. Is that location where you live, Ms. Prisby, is that in Kent County?
It's actually in Montcalm County. It's just outside of Kent County.
And if you were hunting, would it be in Montcalm County as well?
I was going to hunt in Cedar Springs at a friend's house. Currently, I'm not currently on hunting, and I don't have the ability to do so because I don't have a shotgun at this time.
I see.
So my intent is not to hunt this season, but if I wanted to purchase a shotgun for next season, I'm unable to do so.
Well, that would be a little bit too much of a relaxation of the protective order, and I think, it expires under the extension anyway. Let's see here. I think it's before firearm deer season of next year anyway. It'd be right at the start of it. So, yeah, I don't want to relax it to allow you to purchase firearms. It's in place now until November the 9th of 2026. I do appreciate your respecting it and placing those firearms in an area, usually the way it's done for probation and for protective orders is an area that you don't have day-to-day access to or control of. It sounds like your brother-in-law's pole barn fits the bill, and most important here, there hasn't been a continuation of these threats. I get it that there was one, and as recently as 2024, so it's not like this was years and years ago, still fairly fresh in both your minds, clearly from, what you wrote about this. So I think it's best to leave the protective order with its provisions in place at this time, based on the severity of the incidents that occurred in the past, and the fact that you two do need to at least, cross paths in the act of wanting to be present there for your mother, which certainly it seems like the two of you have been able to work out. I know it's not easy with a protective order in place and with two people who aren't necessarily getting along to have to coordinate that, but to your credit, you made it work so far. My feeling here is if we can get through another year of this, until November of next year, without any additional violations or threats, that's number one here is you've heard your sister, Mr. Young, and it would be normal in a confrontation if someone threatened to kill you and you took it seriously. That leaves a lasting mark. That's not something that necessarily fades enough to be comfortable with after 6 months or something like that. And that's why I extended it. However, if we get through another year and there has not been a repeat of that or a similar incident, there haven't been threats, and the two of you are successfully able to see your mom and keep the peace, that would be the time when, I certainly think it might be appropriate for this order to expire or end of its terms. But for now, I'll leave it in place since it's not, you weren't able to hunt the current year anyways, because you don't have the appropriate type of weapon for where you'd be hunting. I don't want to change a ton about your weapon status. Well, the protective orders in place, you can look around and find what you want to buy and then get that, and then you still have time to sight it in before next year's deer season. So I will leave the protective order in place, and that's because of the severity of the prior incident and also the ongoing reality that the two of you will need to pass in close proximity of each other, at least to see your mom. So, and I'm grateful, first of all, that both of you came here. It means you both respect the legal process. And second, that, you've been able to make it work. Like I say, I know it's not easy when there's conflict and a protective order, to kind of fulfill everyone's needs to spend time with a family member, but you two have been working it out like the adult women that you are, and I'm grateful for that. And like I say, if it continues for another year, I'll be much more comfortable terminating the order in a year if the things stay peaceful as they look to me. They've been over the last year. So with that, thanks to both of you for coming, and wishing you a safe holiday. With that, we're concluded.
Thank you so much.
Thank you.
2 protective orders, same lesson. Courts love clear boundaries and calm behavior. In Harrison, the judge sets a temporary 350-yard buffer and saves the big fight for January 29th in Young v. Prisby. The PPO stays through November 9th, 2026, because fear still lingers. Subscribe, like, share, comment below your verdict.